people of South Africa. Members, we have called this meeting to quickly deal with pressing issues. Maybe it's important that we make this announcement that the work of the ad hoc committee is drawing to the end. So in the next 2 weeks, so the ad hoc committee will be wrapping up its testimonies up until the 13th of March. So at least be patient with us until that time. It's only a matter of 2 weeks now. We'll be done and we'll be back fully to be doing the work of the committee. There are a number of issues that need the committee's attention, and when we come back on a Bredenbach, we'll have a serious backlog. So we'll have to do a very clear program of redressing that backlog because we've been away. Members, we will be dealing with the 4 items that appear in the agenda of the committee. Hopefully, it's not going to be a long meeting so that we allow members to travel to the House for the budget speech that starts at 2 in the House. Committee Secretary, do we have any apologies?
Good morning, Chair, and good morning to honorable members and colleagues. We have got an apology from Mr. Swart, who will be attending, he's got a finance committee engagement with the minister. Thank you.
Okay, so it's only Mr. Swart, and it's understandable. Mr. Swart says in the finance committees, and they traditionally have what they call a lock-up. Is it lock-up? Yeah, I think it's lock-up, which happens a day the budget is going to be tabled. Honorable Matafa?
They actually locked down, Chair.
No, it can't be locked down. Is it locked down?
Good morning, Chair and members and guests on the call. Thank you very much, Chair. No, I'm raising my hand to register the apology of Honorable Motaung. She will be joining the meeting a few minutes late as she just got off the bus. Thank you, Chair.
Thank you so much, Matafa.
Chairperson?
Yes, Mr. Ramano.
Honorable Motaung has already joined.
Oh, she has already came.
Yeah, she's on the platform.
No, that's fine then. That's fine. Who is going to table to us the first item, Mr. Ramano?
Chair, the first item deals with salaries.
Yes.
In terms of the agenda that we circulated, we propose that we deal with the salaries of judges and magistrates. We overlooked the salaries of the public protector and the commissioners of the South African Inmates Commission. So I was going to propose that since they are basically the same, we also include the salaries of the public protector and the South African Inmates Commission. And then maybe just to say that in terms of the salaries of magistrates, the recommendation from the president is that there should be a 4.1 salary increase for judges and other public office bearers. So this would mean that the magistrates should be getting a 4.1 salary increase with effect from 1 April 2025. Maybe just to make it short, Chair, in terms of the salaries that we're supposed to be dealing with. The president is recommending 4.1 for judges of the Concord and other and judges of other courts. The president is also recommending a 4.1 increase for salaries of magistrates, a 4.1 increase for salaries of the public protector and the deputy public protector, 4.1 increase for commissioners of the South African Human Rights Commission. All of them effective from 1 April 2025. Maybe just to also indicate that the president says that in arriving at its decision, the Independent Commission for the Remuneration of Public Office Bearers took into account the role, status, duties, functions, and responsibilities of the public office bearers concerned, affordability of different levels of remuneration of public office bearers, current principles and levels of remuneration, particularly in respect of organs of state, inflation, and available resources of the state. So those are basically the considerations that the Commission took into account when coming to a determination of 1.1 salary increase. I think that's all that I can say in terms of the salaries.
Thank you, Mr. Ramano. Have you accepted Mr. Nomvalo?
Chairperson, Mr. Nomvalo is also on the platform.
Yes, I'm in, Chair.
Okay, that's fine. Members, that's the acceptable explanation that we shouldn't be dragging to deal with judges, magistrates, then come back the other day, deal with the commissioners and the public protector. So at least there's synergy in terms of how the president is recommending to Parliament on the increase, 4.1% in all of them, effective from the 1st of April 2025. I need to say this. You'll recall that the last time we dealt with a matter of this nature, there was a huge difference in terms of the increase of judges as compared to that of magistrates. And we had a serious protest from judges to an extent that even the then Chief Justice Zondo, even wrote us a letter that we must halt the process because they still need to engage with the president and all those things. But in this instance, we have got no such a standoff or a protest against this one. We will assume, because there is a general consultation of all stakeholders by the Remuneration Commission. So we'll assume that both all the magistrates, the judges, the public protector, the commission is happy, because consultation is always done with them and the ministry of both the justice and the finance. So members, that's all. It's tabled before you to recommend to the House. Honorable Breitenbach.
Thank you, Honourable Chair. I move that we adopt it.
Thank you. Honorable Matafa.
Now, let me reserve my comments, Chair, and support Honorable Breitenbach that I second the proposal that the report be adopted and recommended to the House. Thank you, Chair.
Thank you, Honorable Mhlala.
No. I just wanted to highlight that good morning, because some of you are not sitting with you in that ad hoc portfolio ad hoc committee. So it's been long not being also in the portfolio committee at the same time. So colleagues, I think in terms of the magistrate, we know very well that they've remained underpaid relative to their workload. Their constitutional role and the principle of judicial independence is very, very important. Even after the president's 4.7 increase or 4.1 increase, 4.7 increase in 2024-25 and the 4.1 adjustment for 2025-26, the magistrates still earn less less than what the judges are earning in the same year. So I think that is a very beautiful thing that is done. And noting also Judicial Officers Association, the JOASA, which actually came before us in Parliament and dealt with these issues, how magistrates are suffering and they end up not being able to end up being frustrated and all those things. I think we don't have a problem with that of the magistrate chairperson, but I'm very worried about this one of the public protector. As much as we cannot say that they must not earn that amount of salary or whatever, but we are concerned because of the office. It seems like the office of the public protector, as much as we are giving him her or him a lot of money like that one, at some point they look like they are supporting the executive more than the public that need to be protected. You look at the issue of Palameta, where they actually just took wrong decisions, to be honest. In a case that is very, everyone generally can see that the decision was not supposed to be like that, but they go and take wrong decision, clearing the president as if now they are the president as protectors. So that thing must come to an end. Let us see the value of money that we are paying these people. No, thanks so much, Chairperson. I pause there. Thank you.
Engor Mhlala, Honorable Tshiamo Tsotetsi.
Thank you, Chairperson. Good morning and to you and honorable members that are in the platform, including the support staff of the committee. Now, Chair, you will remember that magistrates have been engaged in public demonstrations, includes their representatives meeting this committee to raise their problems. There are issues as per the articulation, they only decry the issues of a gap in remuneration. They all have the contents in their king. I've had, as an addition to adopting the recommendations on their salaries, we must also put forward a note, possibly to the department, with strong-wordedly demands that the department must respond to their issues. Their issues mainly are issues that we have also state of infrastructure and state of the courts, which they are expected to operate in, and so forth. So I think that that has been in our table for a long time, and we've said that we are going to engage with them with these issues. I think that as a note coming from these meetings, we must be seen to be saying something about issues that they are raising. All in all, we do agree with the increment, Chair. Thank you very much.
Thank you. Honorable Nomvalo.
Thank you, Chairperson. Good morning to all members who are present here, staff members. It's been a while, comrades. No, Chair, I think we have some practical experience of the living conditions under which the magistrates in particular. I'm not very much concerned about the judges, because I think in terms of salaries, they are well off and they've been taken care of beyond necessary. But with regards to judges for the lower courts, I think we would be not progressive if we don't support an increment which relates to their salaries. And even this increment is not enough. It should be above this. If I was the president, or if I was in that committee, that commission, that remuneration committee, I was going to suggest otherwise. But we can't stand on their way because we know deplorable conditions under which they operate. They came to our to our committee.
Yeah, I used to ad hoc.
I see your face here. So I usually see this face in the ad hoc committee. So I think we would be inconsiderate if we oppose an increment of magistrates. And what makes me, or what makes us as the MK party to be more delighted is that the increment is equal. Even though the salary scales, they are not equal, but the increment is 4.1. I think this also is important, considering our objective of advocating for a single judiciary. So we support this Chair, this increment. We are going to expand our comments more when we are doing declarations in Parliament. Thank you.
Thank you, Honorable Nomvalo. Members, I think in general we agree with the increment, the 4.1 increment, with issues that members are raising to be noted. I see Honorable Nomvalo is already calling the magistrate lower court judges, and you will recall that the memoranda that we received from the regional magistrates and the JOASA, some even made arguments that even this thing of being called magistrates is no longer relevant. They should be called lower court judges. But I think we all agree, members, you'll recall that we have, as part of our prioritization as the committee, we have made the lower courts as part of our priorities because they bear the brand of many problems in terms of the administration of justice. We still have a pending accountability meeting between the committee, JAOSA, the regional court magistrates, the National Treasury, and the Department of Justice in respect of the issues that they have raised with us. So we still have that. We still owe those magistrates that kind of a meeting so that we are able to at least assist and get close to the issues they've been raising with us. So members, thank you very much for...
Chair.
But I'm going to come back to you, Honorable Mani. So in respect of all this, we agree for the 4.1 increment with the particular matters to be noted. Honorable Mani.
Thank you, Chair. No, I'm not going to take you back. I just wanted to ask a question, maybe under general. And Honorable Nomvalo has already spoken behind him, everything that he has said. But I just wanted to ask a principal question. Members of Parliament operate at all different levels. Some are star performers, some are not star performers. But we get our increase nonetheless. I just always wonder whether is it ethical to sit in judgment for others and almost like be in a position to say, no, when you're not performing and therefore this sector is not performing and therefore they must not get kind of thing. Yet in Parliament, we don't have everybody as a star performer, but the increases here are never really challenged. So I'm just asking the principle. We don't have to discuss it now. Just for members to ponder about the justice in this in the process that we're dealing with now. But at least in this particular instance, there's concurrence that no stress. So I'm just saying, going forward, just the principle, is it really correct? And I'm not opening a discussion now, Chair. I'm just planting the seed for a different time, different discussion, but it's something that I must just want to place on the table. Thank you.
Thank you, Honorable Manyi.
Can I come in?
That's well noted. Someone is saying something?
Is Honorable Mhlala chairperson. In future, Honorable Manyi, it must be like that. We are sick and tired of paying members of parliament that are not doing anything at all. We understand that, yes, it's not the principle now, but we will, as the economic freedom fighters, bring this thing forward in future. If you're a member of parliament, you're not doing anything, why must you earn because others are earning, are getting increased? There must be a performance, what do you call that thing? Performance review, something where they check if we are performing. If we are not performing, go home and not get that extra salary that others are getting. Thank you so much. I think that will change this country to the correct direction if we apply that principle. Thank you.
Thank you, Honorable Mhlala. For members, that's noted. I think, as Honorable Manyi says, it's a homework for members to ponder on it. Committee Secretary, can we take the second item? Committee Secretary.
Chairperson, in terms of the agenda, the second item is the filling of vacancies.
Chair, I'm worried about this item. There's no space for others to grandstand as well.
What is that now? Proceed with
This one is grandstanding, chairperson. Be careful of that one. He like to grandstand. And he must always be muted.
Mr. Ramano, please proceed.
Thank you, Chair. Chair, maybe just to say that in terms of the South African Human Rights Commission, members will remember that we started this process last year, and the committee could not agree on the candidates to recommend to the National Assembly. What is needed is a full-time commissioner, and we also need a deputy chairperson of the Human Rights Commission. So the committee adopted a report, which was subsequently adopted by the National Assembly, to say that the process must be started afresh. So we're just bringing it forward to the committee to say that we will be starting the process of re-advertising the vacancy. With regards to the information regulator, we advertised for one full-time member of the regulator and one part-time member. And we have since received nominations and applications, which I said to members yesterday. So the next step now will be the shortlisting of candidates. We have a total of 22 candidates for the two vacancies. But from our side, maybe what we need guidance on, you remember that we've always advertised CVs for public comments. Now the question is, should we advertise all the CVs that we've received? Or should we wait for the committee to shortlist and then advertise the shortlisted candidates for comments? Yeah, I think that's all, Chair, that I can say with regard to the two vacancies.
Thank you. I think it's important to. Okay. Let me start with Honorable Breitenbach.
Thank you, Chair. I think it makes no sense at all to advertise all the CVs. There's a cost factor involved. Let's shortlist and then advertise those that are relevant. Thank you.
Members? Members, are you covered? Okay. Members are covered. Honorable Mhlala?
No, I think I'll support the speaker. Let's advertise, advertise everything. Let's show everything so that there's a principle of fairness and transparency of all the CVs that we received, Chairperson. We don't get to be accused of appointing our people instead of having to have appointed someone whom we hided his or her CV. So let's advertise everything so that when we shortlist, people have an understanding of the people that we have shortlisted, that it was because of this principle, it was because of these requirements. This one met the requirements, this one did not meet the requirements. Thanks so much, Chair.
Yeah, because also I think if we advertise all the CVs, part of the public commentary may be able to give us an insight about some of the things we don't know about candidates, so that we don't shortlist someone at a later stage. We get comments that, by the way, this person, because he has got a hidden criminal record, so he should not have been shortlisted. So I think it's important that let's take them, all of them, to public comments. Some of the public comments will actually determine how we treat some of the candidates in shortlisting. Mr. Ramano, how much time do we need for the public comments so that we're able to gauge the time of shortlisting? I'm worried because the chair of the information regulator has been on my case. They are seriously strained as the regulator with these 2 vacancies. So let's try to be as quick as we can. How much time do we need, Mr. Ramano, for generally? How much time did we advertise CVs for?
No, if I remember correctly, we usually advertise them for a week.
Okay.
So we can try and have the CVs uploaded by the end of this week, and then close the comments
On Friday.
On Friday.
Yeah, then the next week we schedule for interviews. Okay. Mr. Tsotedze?
Well, thank you, Chair. I just wanted to caution the committee in relation to this time that is given for adverts. There's an issue that we were dealing with in my other committee, wherein the Constitutional Court would have reversed the appointment of the Commission on Gender Equality Commissioners on the grounds that not enough time was given to the public, whether for commentary or anything. So you might want to study that judgment, because of course others we would have advertised them in that time period, and then they might not have been having any judgment, but that's because no one might have taken them to court. So we might want to just study that judgment. It's from the Apex Court, and therefore it must be understood to be setting precedents. So my only advice was that perhaps in determining that we must study it and be in compliance. However, it's not explicitly outlining what is a reasonable time period for advertising or issuing of the advert, but it might just need to be considered. That's my input, Chair.
Thank you, Honorable Tsoteti. I think that's a proper input. We definitely should check on that. Of course, that's the part I was interested in was what does the Concord say is a reasonable time for publication of surveys for public comments? But we'll look at it and see if this time we are putting here is in transgression of the principle the Concord is setting. So thank you so much, members. Mr. Romano, let's go to the judges. And also, members, I think we are giving concurrence that the committee must re-advertise the vacancy of the South African Human Rights Commission, as we have long agreed that there needs to be a re-advertisement. So the secretariat must work from today towards the advert. The advert must be out soon. Thank you. Mr. Romano.
Chair, on the issue of judges, I will invite colleagues from legal services to take the committee through.
Who is here to make the presentation from the Constitutional and Legal Services?
Good morning, Chair. Good morning, members. This is Barbara Lewitz from Constitutional Legal Services. I am joined by my colleague, Ms. Ngisa Zanani, and we'll be doing the presentation collectively between the two of us. I'll speak to the first half of the presentation and the process as far as it concerns Judge Makhubele, and Ms. Zanani will speak to the second half and to the portion that addresses Judge Parker. With your permission, Chair, if we can proceed.
Please proceed.
Thank you, Chair. Chair, I know some of the members were part of the process when the committee dealt with former Justices Slope and Mutata, but for just to refresh memories and to bring all members on board, we're just going to start with a brief overview of Section 1771 that sets out the constitutional framework of the responsibilities of the Judicial Service Commission and the National Assembly. That section specifically places two tasks that are equal in nature. It says that the Judicial Service Commission must find that a judge is incapacitated or grossly incompetent or guilty of gross misconduct. And once such a finding has been made, then there is the possibility of the National Assembly calling for that judge to be removed. Such removal must be by way of resolution, and it must be by way of a supporting vote of at least 2/3 of its members. So it's a two-pronged approach. It's not necessarily that if the JSC finds gross misconduct, it's automatic removal. The National Assembly must also apply its mind to the circumstances and then address the issue as to removal as sanction. Of course, this is then where the Portfolio Committee, as an extension of the House, comes in to do the groundwork, consider what the JSC has tabled, and consider the facts of every case. Just then also to remind members that in the 2022 case of Slope versus Judicial Service Commission, the one we refer to in the legal, I want to say space, is the Sutherland judgment, specifically set out that when disciplining judges, the JSC serves as the jury of the nation. So the National Assembly is not charged with considering whether the finding of the JSC is correct. The National Assembly is considering, the task of the National Assembly is to consider, based on that finding and the facts that might be mitigating circumstances, would a sanction of removal be appropriate? So it's not for the National Assembly or by association this committee to second guess the Judicial Service Commission finding, as the court said that the one is not subordinate to the other. So the JSC and the National Assembly here has two different tasks. equal in standing, and it's not for one of those task performers to question the role and the task of the other one. It's not overlapping, it's not subordinate. What the National Assembly here is called to do is to apply its mind, consider the circumstances, and make a political decision whether sanction would be the sanction of removal would be the appropriate a cause to follow here. So this doesn't mean that the National Assembly rubber stamps anything. I think we need to put that up front. Just because the National Assembly is tasked with the question of whether removal should follow, it doesn't mean that it's rubber stamping it. As I said, it's not automatically followed that if the JSC finds a gross incompetence or gross misconduct, that it must give the sanction of removal as an option or as communicated to the president. Then the finding of the JSC is just a jurisdictional precondition before one gets to the question of sanction. So the National Assembly should not consider the merits. It's not questioning whether Judge Makhubele is in fact grossly guilty of gross misconduct, same with Judge Parker. That question has been decided, that jurisdictional precondition has been met, and now the National Assembly is moving on to its task in terms of Section 177. Perhaps just to put in place the Section 14.4 JSC Act grounds that can lead to such a referral as the one before the committee presently. There are 5 grounds. The 14.4a is incapacity giving rise to a judge's inability to perform the function of judicial office in accordance with prevailing standards or gross incompetence or gross misconduct as envisaged in Section 1771A of the Constitution, which is the one I just referred to. Then there are others that speak to willful or grossly negligent breach in terms of the Code of Judicial Conduct. There's a third that says a member that holds or performs an office for profit and receives remuneration that is not within the person's judicial appointment. Anybody who is willful or grossly negligent to fail to comply with a remedial step contemplated in Section 17, which is for transgressions that are not generally regarded as impeachable. So the lower type of transgressions, if there's a remedial action or remedial action contemplated as a step and that person doesn't meet that step, then obviously it kicks up to one of these Section 14.4 grounds. And then another one that is relevant for this discussion is any other willful or grossly negligent conduct other than conduct contemplated in the above listed options that is incompatible with or unbecoming the holding of a judicial office, including any conduct that is prejudicial to the independence, impartiality, dignity, accessibility, efficiency, and effectiveness of the court. Why I like to highlight A and E to the committee here is because members will see in the discussion when we give an overview of the findings of the JSC, there was engagement on both A and E, specifically with regard to Judge Makhubele. So with Judge Makhubele, the referral appears to be constitutional in order. On 1 August, the Chief Justice referred the JSC's finding of gross misconduct against Judge Makhubele to the Speaker, and that was in terms of Section 177. That should be B's, apologies, the 1771B. On 10 November 2025, that report was tabled to the NA and referred to the Portfolio Committee for consideration and report. That members would have received a detailed background outline as prepared by Ms. Nesbitt, and so we won't be going into all the details. It is before members. We are not addressing the validity of the merits of the JSC findings. We are merely setting it out here for context. So on the gross misconduct overview of the process, speaking to Judge Makhubele, it was based on a complaint brought by Unite Behind, and they lodged this complaint in December 2018, and it was based on a 2-part complaint. They said in Part A of their complaint that there was a breach of the separation of powers in that the judge when she was permanently appointed to the bench, did not vacate her post as interim chairperson of the PRASA board, a position which she was offered and accepted by the then Minister of Transport after the date of her interviews, but prior to the date of her appointment. And they said that this failure to vacate that position prior to taking up the permanent position as a judge was a failure that undermined the independence of the judiciary. Part 2 of their complaint was raised or was linked to the fact that they argued that Judge Makhubele's tenure at the interim PRASA board was dishonest, unethical, and lacked integrity, as she improperly interfered with litigation and assisted in obtaining a 50 million settlement for Siaya Group, a state-captured implicated company. So those were their 2 grounds. In February 2020, that 2-part complaint was regarded serious enough by the Chief Justice to refer it to the Judicial Conduct Commission or Conduct Committee, to decide whether it warranted the composition of the Judicial Conduct Tribunal for investigation and reporting. And they did regard this as having sufficient grounds to do so. Following the JSC's consideration of the JCC report, the JCT was therefore constituted. The Judicial Conduct Tribunal's work encountered some delays in that there was a call for the recusal of the first judge appointed as chair. It was Judge Brandt, and he was linked as arbiter to some of the settlement discussions that happened between PRASA and the Siaya Group. That settlement was then later handled out of court, so he did not deal with it directly, but he was associated with that process as a judge, and he therefore stepped down, and it was a former Judge President Japie that then stepped in as the chairperson of the JCT for this process. So there were some delays, but the period eventually between 2023 and 2024 saw the JCT conducting its investigation, and on 9 January 2025, it concluded that on both Part A and Part B of the complaint, Judge Makhubele was guilty in terms of Section 14.4E from the perspective of the JCT. And just to note that the JCT does not make the final finding. That falls to the Judicial Service Commission, but this is their job to report on whether they think there is grounds for a complaint or for a judge to be guilty in terms of one of the grounds set out in the previous slides, to be guilty and for further processing. So this was then considered, this report of the JCT was considered by the small JSC. Members will know that the small JSC is what we refer to the JSC composition of members excluding political delegates, because as Section 177 points out, there's a different role for political decisions to be played after the decision of gross misconduct has been made. So the small JSC considered the JCT report, and on the facts found that the facts actually to the JSC, the small JSC, amounted to gross misconduct. So even though the JSCT, the tribunal itself, in its report said it thinks that this is a case of a 14.4E, which is not necessarily gross misconduct, but that willful negligence, and the last one of the 5 that I pointed out to members in Section 14. The JSC considered the tribunal's report, considered the statements and the testimonies and evidence that it's applying to the JSC, and said, based on that, as gross misconduct falls within the ambit of Section 14.4A, and it is excluded from Section 14.4E, the JCT facts, according to the JSC, supports a guilty finding of gross misconduct. So they then, considering that report, went the gross misconduct route of 14.4A. The same happened with the Part B. They said that the JCT did not add the adjective gross to qualify the misconduct, of which Judge Makhubele was found guilty, while allegations relate to dishonest conduct, which qualifies as gross misconduct in terms of 14.4A. So the JSC, having considered the tribunal's report on Part B, also made that change from 4E to 4A in its final finding as to gross misconduct. We wish to point out to the committee that there is a High Court challenge on the gross misconduct finding. Judge Makhubele has filed with the High Court to review applications challenging the JCT and the JSC processes and findings, specifically taking issue with that replacement by the Commission of 14.4E with 14.4A. We also wish to point out that Parliament has been cited in the matter, but no interdict has been sought to halt the National Assembly's consideration of the Commission's finding as referred to the National Assembly for purposes of its Section 1771B constitutional role. So in terms of the constitutional role, Section 237 of the Constitution says that all constitutional obligations must be performed diligently and without delay. So absent an interdict, and given that the courts have said that the JSC finding is a preconditional fact that must be acknowledged by the National Assembly, and it is not to question the merits thereof, if that fact has not been set aside, and if the National Assembly has not been interdicted from performing its duty in terms of 1771B, diligently and without delay, the committee and the National Assembly must proceed. If at any stage such an interdict application comes in and a court says otherwise, then there is grounds to halt. But currently there is no grounds to halt, and the members of this committee can proceed to consider the possibility of sanction. So the JSC finding has not been set aside, and the finding has been duly tabled in the National Assembly. And as per the Sutherland judgment, the Portfolio Committee is now called to consider that finding and to make a recommendation to the National Assembly whether the removal would be an appropriate sanction. And here I hand over to my colleague, Mr. Nani now. Thank you, Chair.
Thank you.
Thank you, Chairperson. Chair, I shall be addressing the committee on the process that was undertaken by the JSC against Judge Parker. So, in our view, the referral by the Chief Justice appears to be constitutionally in order. It was received on the 7th of January 2026 for the National Assembly to process the referral in terms of Section 1771 subsection B of the Constitution. That's a mistake, the Chairperson. And then on the 28th of January 2026, the JSC report was tabled in the National Assembly and referred to the Portfolio Committee, to this Portfolio Committee for consideration and report. As my colleague has already indicated, a detailed background has been prepared by the committee researcher, Ms. Nesbitt. You may move to the next slide. May I just ask my colleague Barbara to assist me with the slides?
I did move it from my side.
White slide 12 now.
That's the correct slide, yes.
Okay.
Chairperson, as an overview to Judge Parker's process, the initial complaint was lodged in May 2026 by at least 10 judges from the Western Cape Division of the High Court here in Cape Town. The complaint was lodged in terms of Section 14.4A of the JSC Act. The allegations was that of gross misconduct by Judge Parker, in that he gave two mutually exclusive statements under oath regarding his alleged assault by the then Judge President of the division, Dr. J.M. Hlophe. The two statements were given within the context of a complaint that was lodged by with the JSC by the Deputy Judge President of the division, Judge Goliath, against the then Judge President Hlophe. The second complaint was lodged by the Cape Bar Council in terms of sections 14.4B and O, subsection E of the JSC Act. The complaint related to alleged misconduct on the part of Judge Parker, in that he failed to disclose deficits on the trust account of his then law firm at the time when he was undergoing the interview process of becoming a judge. Next slide. Bonani, can you please assist with the slides? I'm not sure who is
Zinkisa, it shows the slide 13 on my side.
All right, I'm on the correct slide. Thanks, colleague. So The two complaints as highlighted above were referred to the JCC to make a determination on whether these complaints warranted a JCT composition for investigation and reporting. The JCC regarded the grounds as sufficient. As such, the JSC, having considered the JCC report, requested the Chief Justice to constitute the JCT. The JCT conducted an investigation and in October 2025 reported on the two allegations and concluded that by giving, number one, by giving the two mutually exclusive versions about the alleged assault, Judge Parker failed to uphold the integrity of the judiciary, and Judge Parker's non-disclosure of the trust account deficit during his judge's interview process was material and gross misconduct on his side. Thanks. The JCT's report was submitted to the JSC on 12 July 2025. The small JSC invited relevant parties to the two complaints to make submissions on the JCT report for further consideration by the small JSC in arriving at its decision on the appropriate verdict. In his submissions, Judge Parker requested the small JSC to note that he had fully cooperated with the JCT in its investigations by not disputing any of the allegations that were made against him. He stated that he had mistakenly misstated the facts in relation to former Judge President Hlophe's assault allegations and sought to correct the mistake once he realized it. He also said that in respect of the trust account deficit, this happened. He became aware of the deficit when he was already a judge. He therefore requested that the small JSC must consider these factors in mitigation of the verdict. On 13 October 2025, having considered the JCT report and its record together with the submissions that have been requested from the relevant parties to the complaint, and by majority decision, the small JSC found Judge Parker to be guilty of gross misconduct in terms of Section 14(4)(a) of the JSC in relation to both complaints as envisaged in Section 177(1)(a) of the Constitution. From here, the steps that this committee needs to consider are as follows. These steps are the steps that the Portfolio Committee on Justice of the 6th Parliament adopted. Step number one, the committee must formally note the findings as legal facts. Secondly, the committee may call for procedural presentations from the JSC if the committee has questions of clarity as to the process that the JSC followed. Thirdly, the committee must invite written representations on extenuating circumstances from the judges who stand to be affected by this process. The committee must also deliberate on whether removal would be the appropriate sanction in the matter. The committee must also report on its recommendations regarding the sanction to the National Assembly, and the National Assembly must consider the recommendation by the committee. Chairperson, I think our presentation in relation to these two matters ends here.
Thank you, Ms. Lutz and Ms. Zanani. So the available options that in respect of these issues is that maybe before we go whether we remove or we don't remove, is whether we're satisfied with the report of the Judicial Service Commission. If not, we write to them to provide much clarity on some aspects that would have identified. If there is no issues with the report in terms of its procedural issues and issues relating to legality, we then are required in terms of the process that ought to be followed to request written representations from both the two affected judges. So members, that's Honorable Nomvalo.
Yeah, no, thanks, Chair. Let's welcome the presentations. I think we're going to rely on the principle that has been set out by the Judge Lope matter. The judgment says there is no institution that is subordinate to the other between the two institutions, Parliament and the JSC. So we're equal in this context. Now, Chair, our view initially before the possible factors have been presented by the latter speaker was that we were going to reserve our right. We're going to say, just give us time to go and apply our minds because we're dealing with delicate matters here. Today, we have a judge sitting down who has 25 years of experience as the judge president of the Western Cape. And amongst the reasons why he was impeached is because of what has been presented here, of a person who made mistakes. And I don't believe it was a mistake, but a person who decided to lie about that judge and competency was compromised. So these are the things that you cannot rush when you are dealing with because they are delicate, they involve careers of people. Even though we have a feeling that this one, the last one, Parker, what has been presented against him here is true. We've got that feeling, but we're not going to make a determination now. Noting his previous questionable character on how he has conducted himself in the Judge Lope matter. But because we're driven by impartiality and objectivity, we're not going to rush to take a decision. So, Chair, our proposition is that let's consider the options that have been presented to us. Let's apply our own mind as Parliament and not rely on what has been presented to us by the JSC. Let's call all the options that have been presented, including calling the affected judges, must be explored, and not say we take this then as nothing but the truth and take a decision based on that. So our position, Chair, as the MK Party, is that let's use the options which have been presented to us by the latter speaker. Thank you.
Thank you, Honorable Nomvalo. Honorable Breitenbach.
Thank you, Chair. I accept the reports as presented, and I think we should go ahead and request that factors in mitigation be sent to us by the affected persons. I see no point in prolonging this process. Thank you.
Thank you, Honorable Mani.
Thank you, Chair. I think firstly, just to confirm that the position articulated by Honorable Nomvalo is a position from the MK side. But I just wanted to just ask almost similar to the last question I posed, a principal question that, the first presenter, apologies, I haven't got all the names properly. He was very firm on the issue of jurisdictional authority and all that. And then said, it's almost like the posture is that where Parliament must just rubber stamp, as it were. But I note the other steps. And I look at also the words that are used in the steps. There are areas where it's a must, there are areas where it's a may. And I know that being lawyers, those are fundamentally different emphasis. The one is peremptory and the other one you may or may not kind of thing. Now, if we have a step, I don't know whether it's because it's the law or what it is. If we have a step that says what the judges say on step 1 must be taken as facts, I have a problem with that. Why must we take it as fact, Chairperson? So I'm just saying that along the lines that Honorable Nombolo was talking, that it looks like the doctrine of separation of powers is breached in the process here, but very sadly so. So I just want to raise my concern that I think we are a parliament or an independent institution, as it were, and therefore our independence must be respected. And indeed, I concur with the position by Honorable Nombalo that will apply our minds, and maybe we might need to interrogate even the facts that were told that we must just swallow them. As it were. I really have a problem with that step 1. Thank you, Chair.
Thank you, Honorable Dana.
Thank you, Chair. Good morning to everyone, and thank you for the presentation. Chair, firstly, I think that the report from the JC, where all the facts and all of the situation as a whole was duly considered, can be accepted. And then also, I think we should just, of the steps on the last slide, we should request mitigating factors from both parties, from both the judges in writing, so we can consider that. And then, Chair, I just have a question with regards to the review application brought by Judge Makhubele. If we continue in the National Assembly and say, for instance, that Judge Makhubele is removed before that application has been heard, what is the implication if that review is indeed upheld? I'd just like to know that. And then also, just lastly, and don't shoot the messenger, Honorable Mani, but I'm just asking, isn't there maybe a conflict of interest for the MK members taking part in the considerations with regards to Judge Parker? And Honorable Nomvalo has already alluded to something around that situation. So it's just a question. And that's all from my side. Thank you.
Thank you. Honorable Matafa.
Thank you very much, Chair. Now, mine was on the issue of the review brought by Judge Makhubele. I think Honorable Dan on that one. And I was also covered on the processes going forward. I think the necessary steps can be initiated because as far as the legal services presentation is concerned, they seem not to have picked up any procedural flaw or gap that would have emanated from the JSC, which would require us to request presence from the body. So requesting the affected parties to make that before making a recommendation to the House. That is my input, Chair. Thank you very much.
Thank you, Honorable Sotetsi.
Thanks, Chair. Just briefly, we do note the presentation. I would believe that it's only fair that this committee also affords the affected parties to make a representation on their side of the story, and then that will empower this committee to make a determination on what is adequate in as far as its powers and powers of parliament are concerned. So I think that is the long and short. Thank you, Chair.
Thank you, Shala.
No, thanks so much, Chairperson. Let me also join my colleagues and note the presentation by the two presenters. Chairperson, as the EFF, we remain firm in our principle. No one is above the law. Judges implicated in gross misconduct, corruption, or dishonesty must face the consequences. The judiciary is the last line of defense for constitutional democracy, and any compromise of its integrity is a direct attack of the people of South Africa. So, Chairperson, as the EFF, we are joining the speakers that says that both judges must be invited to submit written representation on extenuating circumstances which is the step 3 as highlighted in the presentation. Parliament must treat this representation as mitigating factors. So I think let's just, and our principle remains unwavering. All those implicated in state capture or judicial dishonesty must face the consequences. Thanks so much, Chairperson.
Thank you so much, Ms. Lutz and Ms. Sanani, on the issue of the court application by Judge Makhubele and on the issue of the possible conflict raised by Honorable Dena.
Thank you, Chair. Chair, apologies, I was kicked out there for a while, so I hope I heard everything. I'm going to rely on my colleague, Mr. Nani, to also jump in where I might be missing something. On the court application, if and I'm working with fictions now, if the committee recommends that removal should follow, and that goes to the National Assembly on Judge Makhubele, then and the vote goes through on 2/3. If the court sets aside the JSE finding, then the basis for the National Assembly's decision would fall away, and that decision would be as if it doesn't exist anymore. So the National Assembly's decision here is, as said in the with 177 and the Judge Sullivan judgment, it's a precondition. So if the precondition falls away, if a court in a few months sets aside the JSE finding and say it's reviewed and set aside and it doesn't exist, then by implication, any decision that followed based thereon would fall away. So it would not be as if a court decision would set it aside and the National Assembly's fictional decision then on removal would prejudice and go ahead in any case. There would be no further prejudice then, because the slate would be cleared. So we don't see any issue with that. I didn't completely hear the question on conflict, so if I could rely on my colleague, Mr. Nani, to perhaps address that one. Thank you, Chair.
Thank you, Mr. Nani.
Thank you, Chairperson. The question that was asked was whether the MK would be conflicted in relation to the fact that Judge President Hlophe is the member of the committee, is the member of the MKP, and yet his name is mentioned in the Parker matter. Chairperson, unless my colleague holds a contrary view, the policy or the parliamentary code of conduct sets out the grounds upon which a conflict of interest may be identified and how it must be dealt with. On the facts presented and in relation to Judge Parker's complaint about giving two contradicting views on the matter that relates to Judge Hlophe, my preliminary view, Chairperson, is that I do not see why the MK cannot participate in the process. My preliminary view is that there is no conflict of interest in the matter.
Thank you, Mr. Nan. Okay, members, we accept the report as presented. Members are saying we must accord the two affected judges a right to make written representations to the committee. We are going to write letters to both Judge Parker and Judge Makhubele for their written representations. We are going to consider the written or mitigating factors, as some say. In the meeting, we're going to call for deliberations. Today, we were not actually dealing with a removal or not removal. We're actually accepting the report and paving a way forward towards a complete conclusion of the matter by the committee and the recommendation to the House. And I agree with members, this is a very delicate situation that requires us to apply our minds properly, look into the factors, and look into the actual reasoning of the Judicial Services Commission in arriving at this report. Then we'll have a deliberation, therefore, in a date the committee is going to set to specifically deal with both these matters. We request Ms. Lutz and Ms. Zenani that in the meantime, please work on a written legal advice on the issues relating to the court application by Judge Makhubele and the issue related that was raised by Honorable Dena of a possible conflict. I may agree with you now that there is no conflict, but the point is we need to have a well-crafted legal advice to the committee that will form part of our records as we deliberate and proceed with the matters. So members, thank you very much. We're done with this particular item. We are going to make okay, I'm going to come back to you, Mhlala. We're going to make a communication to you on the set date for the deliberation on this matter, Ms. Zanani and Ms. Lutz. Thank you so much. Mhlala?
Yeah, no, I just want to get a
Please also
clarity.
note me, Chair.
Sure.
A clarity from Ms. Zanani and Ms. Lutz. There's somewhere in the presentation where they speak about the JSC and somewhere they say it's a small JSC. So I want to understand what is the difference between the two.
Yeah, they will, but there's a broad Judicial Services Commission that includes all JSC commissioners, everyone from all corners, from all the stakeholders that are represented in the JSC. Then there is what they call the small JSC, a small group that is allowed in terms of law and appointed by the Chief Justice to deal with specific matters that do not really require the entire JSC to look into. So the small JSC, I think the small JSC considered the complaint and advised that the Chief Justice must formulate the Judicial Conduct Tribunal to look into the complaints for both Makhubele and Park. I think that's what the report is saying also. So it's just a group of commissioners that are selected by the Chief Justice amongst the commissioners of the JSC to deal with some specific matters that do not require the full sitting of the JSC. Honorable Nomvalo.
No, you have responded to the question I wanted to ask.
Sure. Honorable Manyi.
Yeah, Chairperson, I would have given a shorthand to say the small JSC is for legal eagles. The broad JSC includes politicians. That's really the shorthand answer. Yeah, no, Chair, on a serious note, I wanted to just welcome the clarification by Mrs. Zenani, because otherwise I had raised my hand to ask the member to withdraw that unfortunate comment and trying to suggest that the MK party is conflicted. But the matter has been professionally addressed, soberly so. So I stand down. Thank you, Chair. Want to really appreciate a question,
Honorable Manyi.
Sorry?
No, I'm saying it was just a question from Honorable Dena.
Yes, that's why I raised my hand to respond to the question. But Mrs. Zenani did a perfect job. Thank you.
Okay, thank you. Honorable Zotez, is that an erstwhile hand?
Yeah, no, it's a legacy hand, Chair. My apology.
Thank you very much, members. Let's step to the last item. Mr. Ramano, who is dealing with the last item?
The content advisor will take us through the last item, which is on
and I'm also worried about both of you. I'm sure you must be fatigued with that ad hoc arrangement. Ms. Silkstone?
Okay, I'm just trying to get at my... Oh, Benani, will you let me share that presentation? Morning members. We haven't seen each other most of us haven't seen each other for quite a while. Well, actually, some of us have seen each other every single day, seems like, but yeah. I hope I haven't got confused, but I have prepared a presentation on a possible study tour to the USA. And so at this stage, it'll be around about 7 days, but we can always work on that. Benani, can I start sharing?
Yes, Chris, you can go ahead.
Okay, now I've got to find it. Sorry, that's not what I wanted to do. Benani, would you mind? Could you flight it?
Okay.
So the presentation, the proposal basically piggybacks on a study tour that was that the committee had got quite far in arranging in the last parliament and was cancelled because there weren't any funds at that stage. So the focus is really on anti-corruption and related justice reforms, and those are specifically relating to, and these are the focuses. There's a component that looks at anti-money laundering and countering terrorist financing and illicit flows. There's a section that looks at witness protection and whistleblower protection. And the third section is, and this is where my fatigue is starting to, yeah. And the third section is on, oh my goodness. Okay, sorry, I'll get there. So yes, responding to growing cyber-enabled corruption and financial crime. Can we go to, so the proposal is that we visit Washington, D.C. If we had more time, we could possibly also then go through to New York for a little bit, but I think that the presentation focuses on Washington. So it's, and possibly New York. Can we move to slide number 4, please? So the context is that we have ongoing anti-corruption reforms following state capture, the allegations that we are now hearing in the ad hoc committee, and in terms of MTDP priorities. So the focus is of those strengthening the AML CFT regime and FAFT compliance, implementation of the Cybercrimes Act and strengthened cybersecurity mechanisms, and a policy focus on professionalizing law enforcement and prosecution services. Next slide. Benani, the next slide. Thanks. So our recent developments, and this is part of what we'll use to motivate the application, is that we have a private members bill, CAV 21, which proposes an independent Chapter 9 anti-corruption institution. And we also have NACAC's report making recommendations regarding South Africa's anti-corruption architecture. We also have, that's not that one. Then the PMB private members bill, CAV, the 20th constitutional amendment bill, proposes an independent Chapter 9 cyber commissioner to address proactive cybersecurity policy and infrastructure.
Through you, Chair, can we just ask the presenter to just do the slide presentation that this thing is bigger? We're squeezing here.
Benani, if you could onto slideshow, you'll get the whole page. Just click on slideshow. Thank you. Is that better, Mr. Manu?
Excellent. Thank you very much.
It's a pleasure. So we've also got, there've been amendments strengthening beneficial ownership transparency. We have proposed reforms to the whistleblower protection framework, which are under review, and calls to strengthen the MPA, IDAC's independence and capacity, and issues around enhanced asset forfeiture and financial intelligence measures. Next slide. So the purpose of the study tour is to engage with our counterpart committees in the US Congress, examine oversight of US executive agencies, examine and benchmark the USA's anti-corruption framework, institutional architecture, and benchmark identified linked focus areas, which I've explained to you, the AML, CFT, illicit outflows frameworks, whistleblower protection and witness protection, cybercrime, and security. Assess prosecutorial independence safeguards there and their resourcing, and identify best practices relevant to South Africa. Next slide, Benani. Thank you. So, this just breaks it down a little bit. So I'm looking at the US anti-corruption framework. We're looking at the institutional architecture and the division of powers. So the role of federal law enforcement and prosecutorial authorities, asset forfeiture and recovery mechanisms, and interagency coordination, oversight, accountability. So that some of the suggested people or institutions that we engage with is the US Department of Justice, the FBI, and the US Office of Government Ethics, the OGE. The next slide. This is the specific focus areas. So anti-money laundering and terrorist financing. So they will be looking at financial intelligence and enforcement mechanisms. And here we drill down to beneficial ownership transparency systems, public-private cooperation in detecting illicit flows, and lessons for strengthening our AML/CFT regime. And here the suggestion is the Financial Crimes Enforcement Network, FinCEN, the FBI, the Department of Justice, and the US Office of Terrorist Financing and Financial Crimes, among others. Next slide. This is whistleblower and witness protection. So we're looking at legal safeguards against retaliation. So we're looking at the institutional independence of protection bodies, the operational design of witness protection programs, incentive-based regimes, and protection in high-level corruption prosecutions. And here we're looking at the US Department of Justice's Witness Security Program and the closely linked the US Marshal Services. And then there is the National Whistleblower Center, which is a NGO or CFO, civil society organization. And the last focus area will be cybersecurity and cybercrime. So here it's combating cyber-enabled corruption and fraud, looking at digital evidence management and prosecution, the national cybersecurity governance structures, cyber task force and federal coordination, and oversight of cyber enforcement within constitutional limits. It suggested the US Department of Justice, the National Computer Forensic Institute. Next slide. So our engagements that are proposed are with the US Congressional Oversight Committees, the Department of Justice and related enforcement agencies, financial intelligence and regulatory authorities, and relevant academic institutions and civil society organizations. Next slide. Our learning objectives are to benchmark policy and legislative frameworks, strengthen our oversight methodologies, and enhance capacity within the state to combat complex and transnational corruption and crime. And then our outcomes will be a comprehensive post-audit report containing evidence-based recommendations, strengthening interparliamentary relationships, and improved oversight. And then Next slide. And then this is just a very high level proposal. So we fly into Washington, D.C. That's not actually captured. That will probably be the Saturday and the Sunday. And then from the Monday, we would start with our itinerary. So that would be Monday to Friday, and then fly out either on the Friday evening or the Saturday morning. Thank you.
Thank you, Ms. Silstone. Mr. Tsoti, is that a new hand?
No, it's not a new hand. I've taken it down.
Okay. Honorable Nomvalo?
Yeah, no, thanks, Chair. Firstly, Chair, I just want to know if the presenters or the team that has been doing this research has considered the political factors, because they are glaring political factors. Before
Let's hope that Honorable Bredenbach is going to intervene on our behalf.
that is the first question. Then the second question is that have they assessed the effectiveness of these legislative frameworks? How effective are they in the US where they apply? Because I thought maybe they are going to, the objective of an oversight is to benchmark so that we can improve our mechanisms in different forms. Now, I thought maybe the presentation will go to an extent of making a reflection on statistics, for instance, to say, as compared to other countries, cyber crimes are at a low level. These are the statistics, and so on and so forth. So have they gone to that extent when they make an assessment? Those are my two questions. Thank you.
Thank you, Honorable Bredenbach.
Thanks, Chair. Yes, the presentation is great and the content is wonderful. I think that we could probably learn a lot from this tour. To answer Honorable Nomvalo, a comparison of the effectiveness of the legislation is that most of the world legislation is based on the American anti-money laundering statutory framework. So we could probably find equally good elsewhere, but I think it's a good place to start. I do think that we should first inquire about the practicality of traveling to the United States. Chair, I agree that there's a glaring political imbalance here, and I'm not at all sure that we would get, that this committee would get visas to travel to America for this. So we should perhaps have a plan B in place, where there are other countries that we could visit to look at the same thing, and have a plan B so that if America will not have us, which I suspect might be the case, that we do have another plan. Thank you.
Done?
Yes, thank you. I'm done. I said thank you.
Thank you. Honorable Mhlala?
No, Chairperson, I think I also, in support of what Honorable Nomvalo has just stated, looking at the politics maybe of what is happening in USA, I heard now Honorable Bredenbach saying that he doesn't see any problem in terms of us getting visas. Recently, we saw the president of that country denying Julius Malema, an honorable member of the Republic of South Africa, the president of the EFF, visa So is it gonna be easy for all of us to go there? Because it seems like the man can just single-handedly take decisions.
So you
We saw
suspect,
things,
you
yeah.
suspect that
we
they
saw-
gave him alone.
no, beside that, Chairperson, we cannot go to a state where what are we saying? We are saying the things that they are doing. They are correct. A man who can just go to another country and arrest another president of another country. And there's nothing that happens. Then we say South Africa must go there and benchmark with that country. I think most of the things that Honorable Nomvalo has stated, I support them. And the issue of the researchers who were doing this presentation, they must also go and research in terms of the statistics of crime in that particular areas, not to just come and motivate us to go there. And they don't bring all the pros and the cons of what we're going to get there. So let's get a thorough presentation before we can say that we accept this presentation. But for me, I think USA is a no-no. We need to identify another countries. There are so many countries that can deal with the issues of we can benchmark from as the country. Thank you so much. More especially in recent situation where we see this man having that superpowers. So I really don't think that the legislation applies in that country rather than a single person just doing his own things. Thank you. I don't even think the judiciary is independent. Everything of that country, I think, is just chaos. Thanks.
Honorable Matafa.
Thank you very much, Chair. Now, let me thank the presentation, Chair, and the work that went into its compilation. Chair, the strategic context of the presentation focuses on issues that South Africa is grappling with, particularly the criminal justice system. And I agree with Honorable Brayton that there will be a lot to learn if this committee undertakes this particular study tour and further supports her view that maybe a second option becomes available. I would have seen in the initial slides that there were countries that were identified other than the USA, that maybe as we engage with the USA, we should then maybe hint to them that we are considering such a tour. And in the event that we get rejected by the US, to this with that particular country. But I think as much as there are tensions, Chair, between South Africa and the US, we should also take into consideration what the president says every time that he responds to the current diplomatic relations with the US. And he maintains that the United States remains a strategic and historic partner and will use all instruments from diplomatic, trade, economy, to be able to maintain that relationship that we have with them from historic times. So I think the request to visit the US by this committee speaks to that as well. To say, yes, diplomatically we might have challenges, but it does not mean that we do not believe that we have a relationship. So I think that we should still proceed and put our application to come through to the US. But just maybe for the benefit of Honorable Mhlala and Honorable Nomvalo, he is rejected the visa of the president of the FF. It is not, well, you can argue that normally the United States and UK sing from the same hymn book. But I think that maybe let's give best they will for the independent the judiciary. If you look at the Supreme Court of judgment now against President Trump on the tariffs executive order, you can see that is some level of independence of the judiciary. So I wouldn't say that the president has direct reach. Maybe in terms of appointment, reshuffling, yes, he does. But on decisions and law enforcement, I think there's still some independence. And I believe that if we undertake this talk, we will benefit greatly. As you look, it also touches not only of security, but it speaks also about money laundering and issues that actually had us grey listed on the FATF. So I support the proposal, Chair, that we consider making contact with the US, but also to underscore what Honorable Brayton is raising, that there must be a plan B. But their plan B also speak to what Honorable was raising, alignment with our legislative framework, and those particular relationships. Thank you very much. Appreciate the presentation and the time to engage.
Honorable Klopa.
Thank you, Chair. I'd just like to second what Honorable Breitenbach has said, and I think it was possibly misheard. She did say that it could create a problem, not that it would create a problem or that it won't create a problem. Honorable Breitenbach said it could be a problem and that a second option just might be viable. So I completely agree. We can continue with this and do the application for it, but have a second option in the event that there's a problem. Thank you, Hassan.
Thank you. Honorable Zodezi.
Yeah, thanks, Chair. Chair, I must say that, when Honorable Breitenbach gives an advice on issues of America and Israel, I tend to believe her. That is on a lighter note. Chair, I think that my view of benchmarking would be that we must take interest in a country that is doing well, but also that has the GDP that is not massively bigger than ours, so that we also gauge ourselves on our ability to implement that which we would have seen other countries doing. I feel there's no point in going to a country that is massively bigger than us in terms of the economy, using far advanced technology to advance their interest. When we come back, we find that we are unable to implement that which we would have seen, regardless of how progressive that is, at least in a medium or long or in a immediate or long period. Now, I would say that the proposal is okay. It must remain as it is. But in the process of looking for alternatives, we put this we put this in mind, that we need to look at the country that is not extremely far from us in terms of the capacity economically to implement that which we must implement in curbing corruption and advancing justice in the country. So I think that I would pause there, Chair. But take that which Breitenbach said, it might be true that we are not going to get visas. Thank you.
Thank you. Ms. Silstone, please take us through on 3 quick things on the process of the application. Does it allow us to bring 3 options of different countries, for example, that USA or France or Venezuela, I'm making an example. Does it allow us to do so? So that as members advise, we are not rigid on USA even at the time when we may find problems. But also I think the International Relations Office of Parliament is available to assist and advise us in terms of the the issues that would have been raised by members. Also speak on the issue of the effectiveness of the focus areas that were chosen in the preferred country and issues relating to the tension. Ms. Silkstone?
On the issue of the process of the application, I will let Benani answer that because that's not,
Okay.
I'm not the expert. But just to say that at the back of my mind, I do have a plan B. What we had done before, one of the other proposals was to go to the Europe and the UK and look at the decrim of sex work, cybersecurity, and witness protection. And that would, the decrim would take us to Switzerland. I think the proposal was Switzerland. Well, the countries that are advanced in those areas are Switzerland, Netherlands, Sweden, and Germany. So possibly maybe Switzerland and Germany, or Switzerland and Sweden, I'm not too sure. Then cybersecurity, that's the UK and Denmark, and witness protection is the UK and Ireland. So, I mean, we could, I don't know what Benani, I don't want to throw this in and then Benani told me it's not viable. If we could have we could make an application for an extended tour and see what visas we get for what. So at the moment, our application would be for a week away, 5 days plus the traveling time on either side. But if we did an application for 2 weeks, we might be able to then cover our bases. But I think let Benani possibly advise on the process.
Mr. Ramana?
Yes, Chair. Yeah, no, when we submit an application, it should be one application. It's like an application for a particular country. We cannot be saying that, you know, if option 1 is not approved, then consider option 2 or option 3. And maybe just to say that, Chair, if we submit an application for the USA and then we run into problems in terms of visas, then it means that we will have to start the process afresh, which might also lead, to some delays. So if the committee agrees, I would suggest that, we look at option 2, which I think will be less of a hassle. Thank you.
Thank you. Okay, let's do like this. Both yourself, Committee Secretary, and the content advisor, please look for an option B. Then present that option B to me on Friday. I will circulate it to members to solicit their views around it. I don't think we really will need a meeting, an official meeting. We are going to just send it to me, so I circulate it to members to solicit their views, so that we just we don't start on doubtful circumstances. It was you can hear that the issue is not make sure. So let's rather look for a safer option. I think Mr. Stone was already making some proposals, so you can work on that, both the committee secretary and the content advisor. So this matter will be finished, because I want us members to start the application as early as this week. I know that that thing takes its own time to be resolved. A lot of processes to be undergone, the chair of chairs and all that. So I want us to submit the application as early as Friday, after having agreed on destination. I think also we must give a particular focus on the focus areas if the country were to choose. Is it the sure I'm coming? Is it the best country to benchmark in respect of those focus areas? I have Mr. Nomvalo. Your hand is up.
Yeah, no, Chair. You would forgive me if I missed it. Which dates are we looking for? I think that is the part. And as a follow-up recommendation, I was going to suggest that maybe we consider a recess because of the workload that we have as the committee. We've missed a lot already. So I don't know if that is possible. But are there any specific dates that they have?
No specific dates as yet. I think that suggestion is taken. They must go as part of the mandate of looking for the destination. They must also look into the dates so that we deal with both of the issues at once. Honorable Mhlala.
No, I think I'm covered, Chairperson, in terms of the dates, because the other thing that we need to take note of, let's not push it too far, because by pushing the dates too far, it end up being affected by the elections. The previous committee that we were in, these trips were approved, but along the way we realized that it is election period and then we cannot go. So let's make sure that we go maybe around recession time, but what is that? Yeah, but it must be early, not far to around August and all those things. And lastly, Chairperson, I heard the content advisor speaking about Germany. I think if we can look at Germany, it makes sense to me because it talks about when you go to research about it in terms of justice matters, they've got powerful constitutional courts, strong separation of powers, professional prosecution services. There's a lot of things that are being mentioned there. I think it can also make sense for us as a committee to go there. Thanks so much, Chair.
Thank you, Honorable Mhlala. That's perfectly noted. Honorable Matava.
Yeah. No, Chair, maybe just on process as Honorable Mr. Rahman was responding. Based on the proposal that Ms. Silkstone was making of 2 applications or 1, and I'm sharing this from past experience, the study towards rules of parliament allows that you can apply in 1 application for 2 countries. So you leave from here to the US and US we jump to Brazil. But obviously that comes with a cost. Maybe in order to avoid a situation of delays that the Raman is saying, we might if the one hits a brick wall. The application can go for 2 countries, and then whichever one that we don't get visas, we just take it off our itinerary to go on the tour. The second part to that, Chair, there are 2 approvals that we have to get, is the political and the financial. In the past, the chair of chairs will say not the entire committee can go given the cost implications. Maybe then either you reduce the length of the study tour or you reduce the size of the delegation. So I would say content advice in Tataraman. When that happens, you decide in terms of how you'd want to compose the delegation. But obviously, Lena speaking for myself, it would be nice for the entire committee to be allowed the opportunity to go on the tour. So I'm just sharing with yourselves that that might arise and the decision might be required. So I would propose for the committee to agree that we give you full powers to make that call. Should it come back and they say, no, maybe the or the cost involved is too much, either you need to reduce the size of the delegation or reduce the size, the length of the. Thank you, Chair.
Thank you. I think on the last part, I think our team has taken the recommendations. We are going to work together to bring a final recommendation on Friday in respect of the destination, the time frame. Do we do 2 full weeks and all that? But I think I will also agree that the application must request that the committee entirely must be part of the study tour. I know those ones will always protest, but from where we have checked with the committee secretary, as the committee will still have enough money left for committee work because the disruption by the ad hoc has made us not to sit regularly. So that's why we still have some funds available for our committee. So hence we must be very quick in securing the application so that we're able to secure and commit those funds. So I think we agree members Friday will be dealing with the issue of the destination, the nature of our study tour. Are we going to one country, or we take one country, then take 4 days, then the next 4 days, another country and all that. So the team will be working on that, the relevant times where we must travel, considering a lot of factors. It's an election year with a backlog. Also, the conditions to the country we're going towards. It's important to even check the climate circumstances. If we're saying we're going in April or May, we must be able to check climate circumstances around May in USA or in whatever country we agree upon. So we're going to work on that and circulate it on Friday. So thank you very much, members. The last issue is that let's officially call for the adoption of the 4.1% salaries for magistrates, judges, commissioners of the South African Human Rights Commission and the Public Protector. So we must formally adopt that. We adopt that. We will send a recommendation to the House. So this is the report of the Portfolio Committee on Justice and Constitutional Development on the draft notice and schedule determining the rate with effect from 1 April 2025 at which salaries, allowances, and benefits are payable to magistrate annually for approval by Parliament in terms of Section 12, subsection 1 of the Magistrate Act 1993, dated the 25th of February 2026. You can scroll up. Members, will just shout when you see something or you want to raise something in respect of any paragraph. You can scroll up. That is the report, members.
Chair.
Yes, Honorable Mani.
Yeah, I was going to just propose that on those bullet points, can you just scroll down?
It's on the last.
Back up on the, yeah, just go back up. We are on 4 now, go back up. I just wanted to propose that on those bullet points, I think that an important thing that we always miss in this kind of discussion is that this is not a performance-related increase. This is just inflationary increase. As it were. I think that's an important point to make because sometimes people say, hey, this one is not performing and all of that. I think we're mixing issues.
It's not a performance bonus.
Yeah, it's not a performance bonus. It's just a normal inflationary increase. So yeah, I just thought it's an important point to make because that's what it is.
No, that's fine.
I'm not saying...
And also, I think we must reflect that in all the reports.
Yeah.
Okay, please add that, Committee Secretary. Can we now move for an adoption of the report of the committee? Honorable Matafa.
Thank you, Chair. I move for the adoption. Thank you.
Honorable Matafa moves for the adoption. Honorable Zodedzi. Honorable Mhlala.
No, it's fine, Chair. You can allow Honorable Zodedzi. It's about the magistrate, this one, eh?
Yes.
No, I second, Chair.
Your second, thank you. Honorable Zodedzi. You have withdrawn. Any objections,
No,
members?
no, Chair, I wanted to second, but I was excited to see the end of Honorable Masala seconding.
Thank you, Honorable Zodedzi. The report on the 4.1 increment of the salaries of magistrates has been duly adopted. The report will be sent to the House. Can we get another report? Draft report of the Justice and Constitutional Development Portfolio Committee on the draft notice and schedule determining the rate with effect from 1 April 2025, at which salaries and allowances are payable to commissioners of the South African Human Rights Commission for approval by Parliament in terms of Section 9, subsection 1 of the South African Human Rights Commission Act, dated 25 February 2026. Can you move, scroll up? You'll just add that in paragraph 2, after the available resources, you add that performance-related issue on Manye was raising. Members, there's a report with that addition. Can we move for the adoption? Honorable Matafa.
I move for adoption, Chair. Thank you.
Honorable Matafa moves for adoption. Seconder. Ms. Sixton, your hand is up.
So, no, Chair, I put it down quickly because you're voting. I just wanted to check, make a proposal around the wording to satisfy Mr. Manye, but I can do that afterwards.
Okay.
After you've, yeah.
Okay, that's fine. Honorable Matafa is moved for the adoption. Members, any seconder?
I'll second, Chair.
Thank you. Honorable Breitenbach seconds. Objections? No objections. Thank you. The report is duly adopted. Can we get the third report, Mr. Ramano? Report of the Portfolio Committee on Justice and Constitutional Development on the draft notice schedule determining the rate with effect from 1 April 2025, at which salaries, allowances are payable to the public protector and double public protector for approval by Parliament in terms of Section 2.2, subsection 2A and 2, capital letter A, subsection 5, paragraph A of the Public Protector Act. Please, dated the 25th of February 2026. Please scroll up. That's the report, members. Can you move for adoption? Honorable Matafa.
I move, Chair. Thank you.
Honorable Matafa moves. Any seconder?
I'll second, Chair.
Honorable Breitenbach seconds. Any objections? No objections. The report is duly adopted. Can you get the last report, Mr. Ramano? Report of the Portfolio Committee on Justice and Constitutional Development on the draft notice and schedule determining the rate with effect from 1 April 2025, at which salaries, allowances, and benefits are payable to Constitutional Court judges and judges of the other courts annually for approval by Parliament in terms of Section 2, subsection 1A of the Judges' Remuneration and Conditions of Employment Act, dated the 25th of February 2026. Can you scroll up? Thank you. That we table the report. Members, can you get an can we move for adoption? Honorable Matafa.
I move for adoption, Chair. Thank you.
Matafa moves for adoption in a seconder.
Yeah, I'll second.
Honorable Klopa seconds. Any objection? No objection. The report is duly adopted. Thank you very much, members. We have adopted all the 4 reports. They will be sent to the House for the final approval. Thank you so much, members. We are done for the meeting of the day. We are going to circulate the issues we have committed relating to the study tour on Friday. Thank you so much. At least you still have time to travel to Parliament for the budget speech, and the meeting is adjourned. Thank you so much and goodbye.
Long live the chair.
Thanks so much, Chair.
Long live the chair, long live the chair, long live the chair.